Welcome to JCEE Connect. Uh, Yesterday's class, we were discussing about the what kind of issues that arbiter can take, and what kind of issues the arbiter cannot take during his normal process. So first of the normal disputes the arbiter can take are: first one is property related issues. Second one is insurance related issues that we have discussed in detail in the last class. So the contract, that is including the employment contracts, business or the partnership disputes, then family disputes, um, then construction in that family disputes, except some of the divorce matters the arbiter cannot take it. Of course he can take it, but the only thing is that it has its own boundaries in that divorce matters. Then construction related activities, if anything is happened between the contractor or um, and between the contractor or the government organizations, if something has happened during the tendering process or during the execution process, even after the execution process, or even during the maintenance period, if any disputes is happened, so whether he is going to solve it or not. Then commercial recoveries, some of the commercial property related issues that can be that kind of issues can be taken by the arbitrator. So then non-arbitral disputes, uh, these are some of the non-arbitral issues that includes matter related to the criminal in nature, criminologies. Suppose if he attempts for criminal activities, if the person is witnessing the criminal activities, so that kind of things will not be taken by the arbiter. So disputes relating to the matrimonial relations, that cannot be taken. So then so the will related, the property will related issues. Then some of the trust, charitable trust issues. Then minors related to the marriage relationship, marriage relations with the minor and the major. Means if the minor is going to marry the major, that kind of issues will not be taken by the arbiter. So then some of the execution proceedings, like court proceedings, uh, that may involve the some of the hanging of the person if he is committing any of the uh, some of the criminal activities. So that kind of proceedings, many of the court proceedings for a sentence to imprisonment, so that kind of activities will not be taken by the arbiter. So means why the arbiter is not going to take all these things, because most of the time these kind of activities will not have the end, because most of the time that may go up to 10 years, 20 years, 15 years, 50 years or 60 years. So there will not be a limited end for these kind of disputes. So whichever the limited you are going to solve it, and within 1 or 2 days or maximum 1 month, any disputes can be solved. That kind of things is taken by the arbiter. So then what kind of duties will be there for the arbiter? The arbiter to administer oath to the parties and the witness appearing. So he has the duty to give the oath for both the parties and the witnesses in that meeting or that arbitration process. to act judicial and impartial. Of course, he should be very impartial. To put necessary interrogatories to any party to dispute. So he can ask any questions or interrogations to any of the parties. He can do that. It's his job. So to determine by and to whom the cost of reference and the award shall be paid. So, and his decision, he can take many suggestions, but the decision has to be done by the arbiter only. So then he has to decide what kind of things has to be awarded. In the arbitration process, you have seen the process how exactly it is going to start and how it is going to end. Starting from the opinions, so it is going to end to give the final award to the um, person who is um, winning that uh, any of the disputes, and to fix the amount, mode and time of payment. So of course he can fix the amount. So how much amount has to be paid by you and the other people, how much amount has to be paid by your uh, to the first party or the second party, or second party to the second first party, and when you should give. And he has to fix the time if any money related issues will be there. So then, so of course arbiter, this is how normally the cycle is going to happen. Arbiter can issues a decision and grant awards, then determines the facts and applies the rules and regulations. How exactly can do that arbiter? Even he can holds the hearings also. It's very simple. If he has taken the decision, if he has done the awards, even he can hold the hearings also, and he can determine the facts and applies rules and regulations. With the help of rules and regulations, he can do many of the things. This is what the duties of the arbiter. So then, what are the advantages of arbitration? So it is the first advantage is that choice of decision maker with expertise. Of course, it can be done. The arbitration process will be carried with a specialization. When it is carrying the specialization, then there will not be any problem in the quality of the decision. So when it comes to the quality of the decision, it should be impartial. Then when it should be impartial, so when the decisions or when the disputes has to be understood by the arbitrator, then how to select this arbitrator? Arbitrator should be selected based on their specialization. For example, if any finance matters or if any income tax related issues, if you give it to one electronic engineer, he cannot solve it. Then it should be given to the person who passed the CA examination. Then only he can understand the dispute. Once he understood the dispute, he can solve it easily and he can convince the both the parties. Then he can tell that what is right and what is wrong for both the parties. So in that cases, normally, mm, if he is not an expert, most of the time the dispute is not going to end, it is going to continue, and the next time both the parties will not come and they will not um contact you for solving the any of the disputes. So he should be very specialized person in that uh, aspects. So, and of course, any disputes can be solved in a day or within 1 hour. Of course, you don't have any time. Even it can be arbiter can solve within a half an hour, within a 2 minutes, within a 5 minutes, or even arbiter can solve the problem 15 days, 20 days. But of course, the speed of the process will be it will be uh, more only. So then lower the cost, because the same thing if you go to the court, the court has to go with many proceedings. It has its own protocols. Some of the protocols he cannot deviate it in some circumstances. In that cases, it it lowers the cost of the hearing also. Of course, it is flexible most of the time, but in some cases, the court type of decisions are not flexible, and the confidentiality. Even you can maintain the confidentiality without knowing the third person. Only the two persons will be known, and the third person will not be known to this dispute. This is one biggest advantage compared to all kinds of advantages what we are doing it. So less formal than court. Of course, it is less formal than court. Then preservation of business relationships. So if you want to preserve the business relationships, you can preserve it. Uh, Many of the business relations you can continue by solving the disputes also. Many times it has happened. Whatever the arbiter is there, he joined the partnership with the first party or the second party by solving, or sometimes he has joined both the parties because he has given the justice for both the peoples. So the judgment should be made in such a way that the both the parties should feel that okay, the decision is good and it is impartial. Then what is the disadvantages of this arbitration? So limited um, recourse, uneven playing field, then lack of transparency. Of course, many arbitrator will try to maintain the transparency, but most of the time, due to some external pressure, even you cannot maintain some of the transparency in the process. But it will not same in the court, because court has to follow the law only. Then he has to follow many of the sections which are displayed in the constitution. But here you can deviate many of the things. Cost, when it comes to the cost, parties pay for the arbitrator and the agency. Of course, here most of the time is a one disadvantage, because most of the time um, the arbiter will demand more to solve the disputes. Some of the professionals are there, professionals arbiters are there. The rate itself is more than if he solve, they will demand lump sum like 50,000, 1 lakh. In that type of things, they will do it. But these things will not happen in the court. Normally, the court charges are well less. Of course, the lawyers will take, but the court charges will be uh, limited compared to this. But in the arbitration process, of course, it is cost is very less. But some of the people will uh, demand more to solve the disputes. Then the limited rights for appeal, fewer means to challenge award. What will happen is that it has limited rights to appeal, means uh, because most I already said that if you take the example of court, you have a session court will be there. Then in the session court, if you are not getting it, will be transferred to the district courts. Even if you are still not satisfied, it will go to high court. If you are not satisfied, it will go to still Supreme Court also. So there are some hierarchies are there. If you are not satisfied, you can go to the different courts at higher level. Then you can justify your self, and you can finally arrive what kind of the decisions are taken or whether it is correct or not. That has to be justified with all this judicial process. But here it won't happen. So once the arbiter is made final, either you should contact the one more arbiter, but most of the time one party will not agree, because in one party will go to the other arbiter, one more party, because he is satisfied, then he will not agree to join this arbiter. So in that cases it is very difficult for appealing and getting awards. Of course, there are many challenges are there for awarding the things. Lack of formal discovery. Okay, lack of formal discovery in the sense some of the formalities related to the what um, either first parties uh, details or the second party details. Um, it is not possible to ask in detail about the first party or the second party, because you are a restricted person. But when it comes to the court, suppose if you apply any issues to the court, you have to submit all the details to the court first. But here it is, no such formalities will be there. So that we are talking about lack of formal discovery is required. So then here you can take an example. Just see this figure. The arbitrator is sitting on the left hand side and the two parties are there. Gentlemen, I take it you are both familiar with the arbitration procedure. Yes, Dad. Then you can see how exactly the process it will be there, and you can see how the both parties are uh, listening to hmm, listening to the matters. Means normally the arbiter is like a prince, and the both the parties, whatever the arbiter has to tell, that they are listening quietly. Means normally many times it happens because once the arbiter is recognized in a top position, um, normally he acts like a prince only. Then whatever he will say, only you have to say yes most of the time, because his standard he has already reached that stage that whatever he will tell, that things has to be asked, or that things has to be uh, um, made as a judgment for both the parties. Means they should, both parties should be humble. You can see that the person is sitting like a prince, and these two peoples are, whatever they are saying, that is uh, mm, whatever these two peoples are, mm, they have to tell only yes. Then what are the types of arbitration process? Then voluntary arbitration and compulsory arbitration. Then what is this voluntary arbitration? It implies that the two contending parties unable to compose their differences by themselves agree to submit the conflict or the dispute to an impartial authority whose decisions they are ready to accept. So it implies, see, whatever the contending parties are there, they unable to compose their differences by themselves, agree to submit the conflict or dispute to an impartial authority whose decisions they are ready to accept. So normally here, whatever the arbiter is there, they acts like only the voluntary arbitration process. Of course, you won't involve in detail discussions. And most of the time, um, here, uh, arbiter is like a volunteer. He don't have that much power to even award it. And here, the both the parties cannot submit any um, dispute related matters to any of the uh, legal persons, saying that the arbiter has uh, done this things, because the arbiter itself is acting like a volunteer. Means we cannot say it is a complete process of arbitration, but um, some arbitration disputes only requires a volunteering process. Means with a small information they can, um, both should can be satisfied. Of course, in depth discovery is not required. Then what are the essential of a voluntary arbitration? The voluntary submission of the dispute uh, to an arbiter, the subsequent attendance of the witness and investigations. These are all some of the main things are required for voluntary arbitration. Attendance of the witness and investigation has to be recorded. The enforcement of an award may not be necessary and binding. Of course, whatever the award you are doing it finally, they are not required. Voluntary arbitration may be specially needed for the disputes arising under agreements and contracts. Then, what is the compulsory arbitration process? It is the one where the parties are required to accept the arbitration without any willing to their part. So, in a voluntary arbitration process, um, the parties, they don't have that much authority to say that why you did um, this kind of things if they are feeling impartial. But here you can claim it because the arbiter itself has um, taken the full power. I'm not a voluntary arbitration. I'll give you the complete details and I'll do the complete discovery of the dispute, and I'll come with the conclusions by doing all these kinds of research. So normally we can call it as compulsory. He has to do the arbitration, and compulsory the both the parties has to fully involve in the arbitration process. But in case of volunteering process, normally either your both the parties will be there with a full power. They will involve with the full power, but either your um, arbiter will involve the full power, but here it is full interest they have to involve. When one of the parties to an industrial dispute feels aggrieved by an act of the other, it may apply to the appropriate government to refer the dispute to an adjudication machinery. Means, normally what will happen is that if both the parties are agreed, even the arbiter is has to agree for arbitration process once, and he is going to award the award also. Sometimes if they feel that this whatever the arbitration process is not completely satisfied by the both the parties, even their involvement is complete, then they may tell to the appropriate government authorities, and they can um, hold this arbitration award, and they can take this to the court. Government in the sense, they can tell to the government, okay, don't for example, if finance matter is there, one tender is there, the tender is having the disputes for both the parties, first contractor and second contractor is there, in between the government they are awarding it. Then if both the one people assume that the tender is awarded to the first party and it is not awarded for the second party, then second party will go to the court saying that, okay, first he will go to the arbiter. Then even in the arbitration process, he's not going to satisfy, because even all three peoples are involved, even the two parties, arbitrator and the government, or all are involved in this process, but still the second party has not satisfied with the decisions what they took by the arbiter. So in that cases, normally the court will order to adjunct or to hold. Normally adjunct means to hold the decision for some days till it is verified by one more arbiter, or it is verified by the court itself, or some of the adjunctable machineries or tools are available. With that they will do it. Then what are the essentials of compulsory arbitration? The country is passing through a grave economic crisis. These are all um, which are the essentials of this compulsory arbitration process. The industries of strategic, maybe this we will discuss in the next class.